Have you been charged with a marijuana DUI in California? If so, you need to know that being under the influence of cannabis while driving is not the same as being impaired. And there are strong legal defenses, especially scientific ones, that can fight these charges. In California, it's illegal to drive under the influence of any drug, including marijuana. But unlike alcohol DUIs, there's no legal per se THC limit, meaning the law doesn't define a clear number that makes you automatically guilty. The prosecution still has to prove that the marijuana actually impaired your ability to drive. And that's where the science falls short. Unlike alcohol, THC can stay in your system for days or even weeks after use, long after any impairing effects are gone. A blood test might show THC in your system, but that doesn't mean you were impaired at the time you were driving. We use expert toxicologists to challenge the results of THC blood tests. They can explain to the court how the THC blood levels do not correlate directly with impairment, that the test detects inactive metabolites that don't affect driving, and how factors like tolerance, time since use, and method of consumption affect a person. Since field sobriety tests were designed for alcohol, not marijuana, an officer's opinion of impairment may be based on subjective observations or non-scientific criteria that are inconsistent with impairment. We've successfully challenged marijuana DUI charges by showing that the so-called signs of impairment like red eyes or slow speech could be caused by allergies, fatigue, or anxiety. Each county handles marijuana DUI cases differently. We've defended clients accused of marijuana DUIs for years. That experience gives us an edge in negotiating with prosecutors and understanding how individual judges view these cases. If you're facing a marijuana DUI charge, don't wait. Call Tiemann Defense at 916-939-3900 for a free confidential consultation. We'll review your case, explore your defenses, and fight to protect your rights.